Okay, so guys, I'd like to introduce to you Lisa Urwin. She's, again, part of TLT, so we're going to continue this round. So round of applause, please. Thank you for staying. Thank you. Thank you, Lisa.
Hi, everyone. Thanks for coming. So I'm Lisa Urwin. I'm a commercial lawyer. I work with John Gill, who was on the panel earlier. We work with TLT, which is a law firm with offices around the UK. One of the sectors we focus on is tech. And yeah, I am a specialist in tech and IP law. So legal issues during the VR product lifecycle is it's quite a broad title. I'm going to try and avoid going into too much detail because it's quite late in the day and I know the bar's calling. I'm going to give you an overview of the main sort of legal issues that might be relevant as you go through the process of bringing a VR product to market, and I really hope that's going to be of use or relevance to some of you. Lately, I've got this idea in my head about law being a kind of virtual reality that's, our structure imposed on everyone else, but I think maybe I'm just trying to make it more interesting than it already is. But yeah, an example of a sort of archaic piece of law that shows that would be this old licensing act of 1872, which says that if you look after a cow when you're drunk, you're liable to like a 40 shillings fine or imprisonment at the discretion of the court. So yeah, let's hope that isn't relevant to any of you. So yeah, I'm going to summarise the legal issues that you might face when you're developing and bringing a product to market. By product, I'm sort of lumping together all different types of product that you might be developing. So game, app, film, etc. And I realise that might be a bit naive, but there's no other way to kind of cover the legal issues. So it might be that some issues are relevant to one type of product and not others, is what I'm trying to say. And I should also point out that I'm qualified in English and Welsh law, so everything I talk about from a legal perspective is from that perspective, although there are some similarities across the different legal regimes. So yeah, I thought it might be useful to try and break it down to consider the different stages of development. And by development, so yeah, I've sort of tried to break it down into 4 stages. The development stage, I really mean planning, engaging a team, writing any scripts and things like that, storyboards, technical development and filming even. And then I'd move on to production, where I'm looking at testing, refining your product prior to launch, and arrangements in advance of going to market. And then selling, I mean selling, putting out there for the consumer, or if you're not selling it at a price, obviously just making it available. And then I'll look quickly at the end of the project. I'm maybe moving on from that project and onto another one, and possibly sort of recycling some of your thoughts and ideas. So development. I mentioned I'm an IP lawyer, an intellectual property rights lawyer. So bear with me for a bit whilst I talk a bit about the different types of IP rights that might come into play. There's copyright. So often when I'm advising particularly startups, I like to explain about the fact that if you've got an idea in your head, it's not protected by copyright. It's only at the point you put that on paper or in some other sort of readable, captured form that it becomes protected by copyright. So it could arise in relation to the text of any notes you're making in planning your product, designs, scripts, storyboards, frames, and so on. Copyright could apply to artwork or images in your product, such as graphics, text in your product, music or sounds, including any narrative or voiceovers which you might want to use. And it also applies to software, including the design materials relating to that code. So they're all things that are capable of copyright protection. Another type of IP right is design rights. So if you create specific characters for your product in a game, perhaps, then that would apply. You can, like copyright, design rights can arise just because you've created the design. You don't have to go out and register them, but if you want longer protection, you go through the process of registering them. And then if you do that through the European registry, you can get 25 years of protection, which is quite useful. And interface elements, you might also get design rights over those. What else under the IP? Oh yeah, another category which is really useful to think about at the planning stage is trademarks. So when you're looking to brand your product, perhaps looking to trademark the name, that'll make it much easier to stop people stealing your brand name in the future, which sounds quite obvious, but you can protect your brand name by registering it with one or more registries. And whilst you're dreaming up your killer brand name, it's good to sort of save hassle and legal fees down the line if you think about running clearance searches early on. So you can check just through searching online initially, are you conflicting with any existing brand names? And then, go into sort of more formal clearance searches to check there's nothing already registered out there that clashes with your brand. And then you could try and get that brand protected by a trademark. And I'd recommend that you do that as soon as possible because in the UK at least, the date that you submit your application to do that is the date that your trademark starts running. So it's good to do early on. And then, just on IP generally, it's a really good idea to just sort of itemise what you're doing and sort of make a list of what you think is yours as you go along. And sort of also in that list break down what might belong to other people, third parties, because then you're sort of already creating evidence of what's yours rather than theirs, and it just makes it a lot easier if you have to go back through that process further down the line. So, let's see what else we've got here. So the next thing I wanted to talk about on this was team engagement and bringing in outside resource. So the terms, often people don't enter into formal arrangements when they're getting a team together. It's just a sort of natural process that evolves. But it is useful from a legal perspective to think about it because one of the things that often gets missed out is how any IP that's being generated when you're working with people is dealt with and protected. So it's really useful to know that under UK law, if you're working with someone and they're not your employee, then any IP rights that they generate whilst they're working for you are theirs rather than yours, even though they're working on your project. So I'd always recommend that you look to put in place written assignments of that IP, which you can do through a service agreement with them, a consultancy agreement, freelance agreement, whatever you want to call it, or just an IP assignment document. So it's a good thing to think about. And then at this stage, I'm going to talk a little bit about third-party terms. So those could include terms that might apply when you're using a third-party resource, such as a development framework. It's worth noting that sometimes the resource won't always point those terms out to you, so they'll just be sitting on their website. And sometimes companies will make you tick a box or sign terms to accept them, or they might just say in those terms that they apply just because you're using their product. So just sort of be wary of that. If you're using a third-party tool, then the IP rights in that tool are usually protected as theirs. It's very uncommon that they give you those rights. It sounds simple, but just because you're incorporating something into your product doesn't make it yours. For example, if you bring in interface elements into a game that you source from a third party, the third party is likely to see those elements as theirs and not yours, even if they're open source. So, and on that, on open source, certain license restrictions could apply, even like, for example, the need to credit someone. So yeah, be wary of that. And even at this stage, you might be thinking about arranging how your product will be made available to consumers once it's ready for market. If you're using a third-party sales platform or hardware, there'll probably be platform-specific terms that you should read through. It's quite hard to negotiate those terms, but if there's anything in there that you read that you really cannot live with, you should always contact the platform and try and iron that out, because otherwise you're just bound by it, and that might cause problems. I'd say through experience it's much easier to negotiate if you've got a genuine business reason for wanting to change something, rather than just trying to cherry pick and get the best deal you can. But yeah, anything you can't live with, you should try and iron out. So next exciting slide. Sorry, slides are not my forte. So a little bit more on third-party terms. When you look to make your product available through a specific platform, check your obligations around delivery and approvals, timings in particular. It could be that the platform has their own testing requirements and you have to deliver the product for testing by a certain window in advance of launch. If you miss that, or if they, for example, require approval in stages and you don't hit the deadlines, that could potentially give them the right to reject your product, cancel the terms, and might make you miss your launch window. So just think about that. Also, if you've agreed to supply a certain product, which you might do, and then your scope changes and slips as you go along, you might find that you need to look back and check that what you've agreed to deliver, you might need to change it through agreement with them. So your specification might change and you need to agree that. It's much easier if you agree that up front before delivering something they're not expecting. And then also on this, I thought I'd talk about health and safety, which I think probably in previous years at this conference and sort of generally there's been a lot of discussion around health and safety in VR. And one of the problems, I guess, from a developer perspective under UK law is it's not possible to exclude your liability for personal injury. So if you think that might be fair from the consumer's point of view, that's fine, but it means that the burden of that liability will have to rest with someone in the chain of the contract. So I think you'll probably always find that the hardware or platform providers will shift that burden down onto the product developer rather than them. So in terms of trying to minimise your resulting risk, again, look at the clauses in any contracts or terms that you've signed up to, and if you can try and narrow the scope of your exposure at all, it's a good idea to try and do that. So, for example, I've seen clauses where you might be required to indemnify the company, the platform, and all of their affiliate companies, all of their shareholders, all of their assigns, etc., and that's a huge risk on your part. If someone in the US, for example, has a health and safety claim against them because of your product, then you could end up having to pay a lot of money to a lot of people. And you're not likely to be able to get insurance to cover that. So you might want to think about trying to put a financial cap on the amount, if particularly in an ideal world that would neatly match up with your insurance level, but whether or not you can get that in the first place, I don't know. But then I guess the other way to sort of minimise that risk is do testing, take steps from a practical perspective. So, if there are any motion issues, try and resolve those before you go to market. So next, thinking about making content available to consumers. So you should be aware that the law implies terms that protect the consumer, as I'm sure you know. You might not know that the law's sort of changed in the last couple of years and now applies specifically to digital products as well. So that now gives the consumer more rights in terms of the sort of product you might be launching. For example, it might give them the right to be reimbursed for defective paid-for content. So if something you've done goes wrong, you might have to reimburse them. Worth thinking about. Also, data protection law. Could do a whole presentation just on data protection law, but just as a sort of a reminder, that applies to any personal data you might gather from users of your product. And the golden rule is to try and get consent to how you're going to use that data from them before you take it, when you collect it. And you need to make sure you store it and use it in compliance with the law. Next year, in May, there's going to be a new general data protection regulation, which is going to set out higher standards for getting consent. So you might want to start thinking about that. And then, on making content available, I mentioned at the beginning that I'm an English law lawyer. Quite often, again, in sort of third-party terms, you might find that they're governed by US law or the laws of a particular US state, which, can be very particular from experience. You can look to try and change this because obviously if you're sort of aware of the legal position from an English law perspective, you don't want to be signing up to US law. I would say it's really, really hard to try and convince someone to switch the law from US to English law, but one way to sort of get around any risks is to take advice from a US lawyer if you're really worried about something like that, or just try and find out more about it. So, moving on, this is when you get to, your product's doing really well, you're hitting your target sales figures, and you sort of the project's starting to wind down, I suppose, or maybe not, maybe it keeps going, but you're looking to try and do something else. So what do you need to think about from a legal perspective? It might sound obvious, but if you've got terms in place with platforms and sales platforms, then it could be that they require you to keep your product up and being made available for a very long period of time or indefinitely. So I'd think about that at the outset and try and work out how long you want it to be up there for. I was quite surprised to see that sort of the expectation was that content would be up forever, which you might not want. You might want quality control, and you might not want consumers having sort of outdated products being made available to them for a long time. So think about that and try and deal with that when you start. And if you want to be able to get out of a set of terms, you obviously need to have the ability to do that in them, so check any termination provisions. And then, back to IP rights. So I mentioned sort of working out who owns what in terms of IP rights and who's got what when you're working with third parties. It's really useful to have gone through that process at the start of your product's life cycle, because then when you get to sort of nearer the end and say you want to use certain elements from that product in a new one, you'll be able to easily identify who owns what. And if you need to get a license to use something with another product, you can do that more easily, or hopefully you'll own it all and you can just go off and do what you want. And so that was it really. I hope it's useful. Certainly if there's anything that you want specific advice on, I mean, we've got time for questions now, so if anyone's got any specific questions, or I'll be hanging around sort of throughout the conference if anyone wants to ask anything else.
Thank you, Lisa. Does anyone have any questions? Because again, these are very important chats that we've got going on, finance, legal, things like that. We are going to be encountering at some point or another, especially if you are having a startup or running your own business or involved with IP. Does anyone have questions for Lisa? Oh, cool. Oh, yes, sorry, sir. I'm sorry.
Hi.
Hi, thanks for the talk. I just wanted to ask in general about rating systems, and if you're talking about violence in a normal kind of movie, it feels kind of easy to have a rating, if it's really bloody, 18 or whatever, there's no risk of that happening. In VR, it feels, I don't think there really is anything.
There isn't at the moment, no.
But if there's, let's say if a boulder's rolling towards you, an 8-year-old and an 8-year-old the age isn't going to really apply in how they react. Someone might be really, really shocked by a boulder crushing them, and someone else might laugh it off, and someone else might even be kind of scarred in some really weird way. Is there something that we can kind of do as developers to kind of take that into account and stop anyone from being affected in a negative way?
Well, I mean, from a legal perspective, there isn't a classification system yet. I mean, so the sort of legal position that you're looking at is not sort of, I suppose it would be the health and safety aspect. Are you going to cause anyone any psychological damage by exposing them to that and leading them to sort of have a potential claim against you? I think that's quite extreme, but it's not unheard of, I suppose, or not impossible. From a practical perspective, you might want to think about applying a similar, or self-enforcing a similar system to the film classification system, for example. There are some gaming bodies that have their own sort of self-source system as well that you could apply, and that would be good practice. But really, it's common sense, I suppose. If something's really gonna cause people distress, and particularly with VR, you know, you are dealing with stuff coming straight towards you, then you might want to think about applying warning systems. I've certainly advised on people to giving out guidance on how to use their product, and in that, you know, you could perhaps specify how it might be suitable for some people and not others, and why. I suppose that's the best answer I can give. Thanks.
And we had some questions down in the front. Either way. Ladies first. We'll do that.
Hi there, my name is Vera, I'm from Virtual Village.
Hi.
And I've got kind of two questions. The first one is also health related. So
Okay.
I was wondering, can users actually sue us if they experience some nausea or things like that?
So it would have to be quite extreme, I suppose. They'd have to like have a sort of physiological or psychological effect, but technically, yes,
Because everyone has a different experience, isn't it? Because I know some people can just take it all, and others like feel nausea.
Yeah, I mean it's different in
quickly.
different countries. So there's a much potentially lower bar in places like the US for people to sue for things like that. In the UK, there's certainly not loads of like case law demonstrating how people have successfully sued for like VR nausea, but there's nothing to stop someone bringing what we'd call a test case and trying to do that and trying to say that they'd suffered damage and that therefore you needed to pay them for it.
So how could I avoid that people sue because of
Well, yeah, so you can't exclude liability for people having personal injury, but you can try and minimize that risk by user guides, testing, trying to iron out anything like that, giving warnings with the product in your user guides or whatever. It's a problem of the industry that's sort of recognized, but it's just going to evolve, and I guess unfortunately, until someone does sue successfully, there's not going to be a way that we can tell you how to get around that. But I think just common sense.
Okay, and you kind of touched on my second question. So, everything digital is kind of international. Anyway, so if I launch something, but in the company is situated in the UK, could it still be that people from the US, like users, sue me because of a different law? So how can I react to that? What can we do?
Yeah. So the thing about that particular area of law is that it wouldn't be tied into your contract with them. They could potentially just try and sue you anyway. But I mean,
have you been to America?
I'm not dissing US law. I'm just saying it's different. So yeah, I mean the one thing that they might try and do before they try and sue you as a developer is sue the hardware provider or the platform, because quite frankly they've got a lot of money and they would try and go after them. But as I was saying, the problem with that is that they would try and shift that liability down onto you, and they probably would in their standard terms. So it's a difficult position. You can look to try and protect yourself through operating through your specific company, which would be limited in the UK potentially, or dealing with it that way. But yeah,
they could still sue the company. So a limited company, they can sue.
I mean,
PVOC.
it would be really difficult. I suppose they would have to. It would be really difficult. I don't know the answer. I'll think about it and I'll come and find you.
Maybe we need some standards in the VR sector, and people should think about.
Yeah, well, I think it's safe to say that as it evolves, probably stuff will become standardised. I mean, that's happening across the industry, isn't it? So that approach will become standardised.
And we've got time for one more question before we change into our last panel. And then again, remember beer, code word beer. Lisa will be around. So.
I think I need a bit. Yeah.
My question was about IP, assigning IP.
Yeah.
And we're going to be doing a motion capture film with a group of dancers.
Oh, cool.
And this is going to be a new piece. I've never made a film before. They've never made anything that's digital and immersive before.
Okay.
So they're friends of mine, so we want to sit down and have a conversation about assigning the IP before we go too deeply.
Yeah.
On the rough hand, it looks like I'll be the producer and they'll be the artistic director. That's how it's aligned with the roles. But what's the tips you could give for having a conversation to open that out?
So are they operating through one company with you, or are they all operating as individuals, or how will it work?
They'll be an individual.
Yeah,
but they also have a separate company for other stuff.
I mean, in terms of the IP that they're generating, dance is a really interesting area because it's actually quite hard to demonstrate IP in the dance itself. So, but if there's sort of set choreography and things like that, that could form a basis of IP. There'd also be potentially some IP in the fact that you're filming them and using their sort of images. So my advice would be to sort of obtain a generic assignment of any IP, and I would sort of define that really broadly over to you just to be on the safe side, and enter into kind of like a service type agreement with them whereby it's clear that you're paying them X, they're doing this for you, and they're also giving you that IP across to you to the extent it exists.
Fantastic. Thank you so much, Lisa.
Thanks,
Big,
everyone.
big, big round of applause. Very important talk. Very, very important.